Ghost gun laws just took another hit. Welcome to another installment of the Connecticut Gun Bench. Today's video is brought to you by P.A.N. Firearms, LLC. P.A.N. Firearms for NRA certification and multifaceted gun training. You can reach us at 203-300-6343 or use our website at www.panfirearmsllc.com. As always, there'll be a link in the description box below. And let's talk about this. There is currently a legal challenge to the Delaware, state of Delaware, to their HB 125, which has two parts. One, it bans the manufacture, possession, and distribution of so-called ghost guns or unserialized firearm parts. And part two, it's a 3D printer law where you cannot use a 3D printer to make, possess, distribute. But this came under a legal challenge, and the judge in this case, and her name is Norieka. I hope I said that right. But the suit was brought forward by John RIGBY, Alan Knight, with the support of the Firearms Policy Coalition. Okay, so what has happened here is this judge has passed down an injunction because they were arguing two separate cases. One against the ownership of so-called ghost guns, and the other denying the use of 3D printers or the distribution of the software that is used to make 3D parts. So I've read this document. It's only it's 22 pages long. A lot of legal jargon, but there's some really good information in here, and you should go ahead and read it. Now, I'm gonna be jumping around in this because there's information on each part. And as I go through each page, I'm gonna put the whole thing up here. I'm gonna try to get this up on my description box so you can pull it up and read it, if I can find it, because I have a PDF of it. But let me just get to the nuts and bolts. Okay, so plaintiffs, this is a opening line. Plaintiffs Alan Knight, John RIGBY, and Firearms Policy Coalition Incorporated, collectively plaintiffs, filed a complaint challenging several recently enacted Delaware statutes as unconstitutional. Soon thereafter, they filed a motion for a preliminary and permanent injunction seeking to enjoin defendant from enforcing those statutes, prevent the state of Delaware from enforcing their laws. Defendant has moved to dismiss plaintiff's complaint for failure to state a claim. For the following reasons, plaintiff's motion for preliminary injunction is granted in part and denied in part. Remember, I told you there are two separate parts. One against ghost guns and the other one against the software that is used in 3D printers, the distribution of it. So those are the two parts, okay? Now, she granted the injunction on the ghost gun part, and I'm going to get into depth in that. She denied the motion on the use of software for 3D printers because they tried to use a First Amendment argument and she wasn't really buying it. But I'm going to jump around. Okay, here we go. And okay, so this is going to be on page 1. Okay, and this is talking about basically it's federal firearms regulation. She goes into a little background. That's on page 1. But then when you come down to here, this is where I want to jump to. You kind of have to read this to get a little context, but this is talking about the 1934 Gun Control Act and 1938 Gun Control Act. That's her foundation that she's working with. But she comes down to here, which it gets interesting. This is on page 2. Once again, find this document, it's very interesting. As time passed, these decade-old definitions grew stale. Traditionally, weapons had a single frame that housed the hammer, bolt, or breech block and firing mechanism of frame or receiver identification. Yeah, right. Certain modern firearms, however, have replaced the hammer with a striker, which is not included in the above definition. Moreover, split piece and multi-piece receivers, which do not house the hammer, bolt, and breech block in a single frame, have recently become popular. These receivers do not meet the definition above and therefore fall outside of the Gun Control Act scope, 1934-38. The result is that entities have been manufacturing and selling kits containing split frame and multi-frame receivers and the tools necessary to complete the weapon to a functional state with minimal effort, expertise, or equipment without being subject to the requirements of the Gun Control Act. And these weapons produced by these kits are unserialized and untraceable, and no background check is conducted to ensure that purchasers may lawfully possess a firearm in accordance with federal and state law. April 2022, the Bureau of Alcohol, Tobacco, Firearms, and Explosives published a final rule that altered the definition of firearm and firearm frame or receiver in an attempt to close the loophole that allowed unserialized weapons to proliferate. Final rule definition, that she gets into the legal aspect of it. Under the final rule, unfinished firearm kits that were arguably not subject to the Gun Control Act's mandates with respects to serialization, background checks, and record keeping are now subject to those requirements. You just saw that come through recently. The challenged Delaware statute described below were passed prior to the publication of the final rule. And now they're talking about House Bill 125 in Delaware, which banned the manufacture, sale, possession of ghost guns. Now, I'm going to jump down to page 5, which states, HB 125 also contains regulations that plaintiffs do not challenge. For example, HB 125 makes it a felony to knowingly transport, ship, possess, or receive any firearm or firearm frame or receiver with the knowledge that the importer's or manufacturer's serial number has been removed, obliterated, or altered in any manner that has disguised or concealed the identity or origin of the firearm. They don't care about that. These are two guys who were just making these parts and frames in their home for themselves. So they never argued that point of distributing, because that was never their intention. But it's very interesting. But there. Okay, and I'm going to come down. Now this is describing the two defendants, plaintiffs, RIGBY and Knight. John RIGBY is a resident of Delaware who self-manufactured a handgun that he removed out of state due to fear of criminal sanction due to HB 125. Wishes to manufacture firearms with firearm components that he owns, and owns a 3D printer with the desired intent to use it to manufacture firearms using code that he possesses. But for HB 125, Plaintiff RIGBY avers that he would still possess his self-manufactured handgun, continue building firearms, and distribute code that may be used to manufacture firearms on a 3D printer. Plaintiff Alan Knight is a Delaware resident who owns and possesses two unserialized, unfinished receivers suitable for the manufacturing and assembly of an AR-15 design rifle. Knight asserts that he wishes to use these firearm components to manufacture a firearm for his own use and not to sell or otherwise dispose of it. Knight also desired to obtain additional firearm components to manufacture firearms for his own use. Okay, now they talk about the Firearm Policy Coalition, who basically joined with these two people. You could just say that, financial support, but I'm going to come down to page 9. Okay. Now, these are talking about the likelihood of success on the merits, but these are the two separate issues, a Second Amendment issue and a First Amendment issue. But it talks about NYSRPA versus Bruin. This is what the judge is referring to. Although Bruin displaced the previous text employed by the Court of Appeals, Bruin is not altogether new. Indeed, the court must still ask first whether the challenge law burdens the Second Amendment. Okay? How Bruin did not displace the previous test first step, and if so, then the court must determine whether the statutes are consistent with the nation's historical tradition of firearm regulations. And then she goes through the individual parts of HB 125 as it pertains to ghost guns, distribution, possession, and manufacture. Like I said, I'm going to try to get this into the description box so you can read it. Okay. Now, I'm going to come down to page 12, right here. Okay. In contrast to the states regulating distribution of firearms, the contested statutes prohibiting the possession of unfinished frames and receivers and untraceable firearms do burden rights protected by the Second Amendment. This is the judge. The Second Amendment, which protects the right of the people to keep and bear arms, protects the possession of untraceable firearms and unfinished firearms and receivers because the text covers the possession of firearms. Okay, and he talks about the specific sections that were there. Okay, you go right to here, and it says, thus the Second Amendment presumptively extends to the conduct prohibited by these statutes. Now, defendant asserts that these statutes do not protect conduct protected by the Second Amendment because unfinished frames and receivers and untraceable firearms are not in common use. That is a bad argument because the items that you are making with these parts and unserialized items do actually make firearms that are in common use. AR-15 receiver becomes an AR-15. That is in common use. A Glock lower that's unfinished that you finish is now a Glock. Once again, it's in common use. That's a bad argument on part of the state. But this is the judge speaking. Okay, not in common use and typically possessed by law-abiding citizens for lawful purposes. Defendant, however, has offered no evidence to support the assertion. Indeed, defendant's evidence on this point consists of a single statistic that law enforcement recovered almost 24,000 untraceable firearms at crime scenes nationwide between 2016 and 2020. Although this indicates that untraceable firearms are at times used by criminals, it ignores that firearms unquestionably protected by the Second Amendment are also sometimes used by criminals. What is important is whether the prohibited untraceable firearms and unfinished firearm components are not typically possessed by law-abiding citizens for lawful purposes. On the record currently before the court, defendant has failed to provide evidence that persuades the court that this standard has been met. Therefore, the court finds that these statutes burden rights protected by the Second Amendment. And I'm going to come down to page 14. Okay. Turning, once again, this is a judge. Turning to the second step in the Bruin analysis, the court finds that the defendant has not demonstrated that the two statutes, 1459A and 1463, are consistent with the nation's historical tradition of firearm regulation, referring to Bruin. Defendant argues that laws tracking and restricting the possession of firearms date back to colonial times and that serialization dates to the same period as Heller's example and should be considered a long-standing, presumptively valid measure. But defendant has not identified a single statute or regulation to substantiate her argument. Okay, now I'm going to come down to page 15. Plaintiff also contend that those portions that prohibit manufacturing untraceable firearms are unconstitutional. Defendant again asserts that this regulation concerns conduct that is not protected by the Second Amendment. The court disagrees and cites Ezel versus City of Chicago. The Seventh Circuit struck down a Chicago ordinance that simultaneously permitted only those who have trained at a firing range to possess firearms and barred firing ranges within city limits. Okay, so I'm trying to get through as much because there's a lot of information here. I'm gonna come down now to page 20. Okay, skip over the legal stuff and get to the nuts and bolts. Okay, here we go. Okay, this is about irreparable harm. Okay, to show irreparable harm, a plaintiff must demonstrate potential harm which cannot be redressed by a legal or an equitable remedy following a trial, and states Acerno versus Newcastle County as a case study. When an alleged deprivation of a constitutional right is involved, most courts hold that no further showing of irreparable injury is necessary. Here, plaintiffs face irreparable harm in the absence of an injunction because they are threatened by criminal penalties should they engage in conduct protected by the Second Amendment. This element therefore weighs in favor of granting injunctive relief. And I don't need to get any further into that. Okay. So as you see, this judge here basically just said, yeah, you have a right to have a firearm with no serial number on it, and you basically can have one and you can manufacture it and possess it. This of course has massive implications on all the ghost gun laws that have been popping up around the nation, because obviously this is just an injunction against Delaware enforcing HB 125. So where's it going to go from here? It's going to go to the next court level, and sooner or later it's going to end up at the Supreme Court. And once again, we're going to have literally national precedent on the manufacture, possession of untraceable is a dumb word, but it's the one that works, untraceable, unserialized firearms. This is huge. We need to pay attention to this. This is one victory here, Delaware. Delaware, if they let it go, it won't go to the next level. If they just say, okay, fine, we're going to just dismiss all our gun laws. If they say, nope, we believe we are right and take it to the next level, it's going to go all the way to the top. And now we have national precedent on ghost gun laws. And I'm sure these states that have these ghost gun laws are probably have this same document that I am reading. And like I said, I will try to get this into the description box so you can read this yourself. It's a lot. It's only 22 pages, but a lot of information in there. You should read it. Okay? But this is exciting news. Let me know what you think. As always, you can leave your comments in the comment section below. And as always, any statements of violence or statements that lead to violence will be removed. Please like, share, comment, subscribe. Don't forget to hit the notification bell so you're notified the next time a video goes live. I will see you on the next one. Peace.